Good morning. The Honorable Chief Justice of India, Justice D.Y. Chandrachud, has given a creative interpretation with respect to Article 200 of the Constitution, and we are putting this in the form of the state of Punjab versus Principal Secretary to the Governor of Punjab and another. What exactly is this? Before going into the details of this, let me discuss a few points regarding Article 200 of the Constitution. But before going to Article number 200, let me tell you one more important point which we already know, that every state is headed by the governor. Governor is considered to be the first citizen at the state level, and those governors are appointed by President of India on the advice of the Council of Ministers headed by the Prime Minister. We all know these points, meaning who should be appointed as the governor will be decided by the Prime Minister, and the name will be recommended to the President of India, and the President is appointing such person as the governor of a particular state. So this is what the Constitution says, and this is what is being followed in India. But what happens now when you come to the state level? You have the legislature at the state level, which is meant for making the legislations. Here, bills are introduced, bills are passed, then that will be forwarded to Raj Bhavan for the assent of the governor of the concerned state. With the governor's consent, those bills will become the act. Then that will be implemented. But because of the political differences, many times in many states we see the governor is appointed by central government, and the central government belongs to one political party and different political party at the state level in larger states. Then obviously what will happen? You want to apply brakes to the speed of the state government. One mechanism is that the governor can withhold the bills. Withhold the bills, don't give assent, and just sit on the bills for years together. So that what will happen? So the state government will keep on sending the reminders and requests to the Raj Bhavan, and the governor will not respond. Out of so many bills, one bill may be given assent, which is considered to be not so important. Clear? So if this is the situation, how exactly the state governments will function? That is the reason why this particular issue has reached the so-called the Supreme Court. Supreme Court also noticed that governors are sitting on the bills, and governors sometimes they are sending the bills for the consideration of the president. But what exactly is the Constitution Article number 200 is saying on this? Article number 200 is very clear that once the bills are passed by the legislature, governor gives the assent and it will become act, or governor may send back those bills for the reconsideration of the legislature. After such reconsideration, with or without amendments, once the bills go back to the governor has to give the assent and it will become the act. Clear? So this is what the Constitution says. But the same Article 200 is also saying that the governor may reserve the bills for the consideration of the president. But the point is that whether all the bills can be reserved for the consideration of the president, or any specific bills can be reserved for the consideration of the president. Obviously, not all the bills, and the Constitution is very clear that such bills that derogate the powers of the High Court can be withheld and reserved for the consideration of the president. Rest all the bills must be cleared by the governor at the state level. So this is what the Constitution is very clear. But what is happening? The governor once receives the bills, the governor is sitting on the bills for a longer period, number one. Number two, and after sitting over a period of time, those bills he is sending for the consideration of the president. Obviously, that will delay the process at the state level. Hence, if you look at the Kerala state, 8 bills have been sent by the state government to the the governor. After sitting on the bills for 2 to 3 years, the governor gave consent for, this is just one bill, and rest have been sent to the consideration of the president. In Tamil Nadu, 10 bills were pending with the governor, and all the 10 have been sent back to the legislature for the reconsideration. And the legislature has passed the bills without any amendments, and the bills have reached the Raj Bhavan. Under the constitution, what should be done? Governor has to give the assent, and all the 10 bills will become the act. But instead of that one, governor has forwarded all the 10 bills to the consideration of the president, where the constitution is not mentioning such power to the governor. Of course, constitution has mentioned the such an discretionary powers to the governor, but whether the discretionary powers are applicable under this article 200 or not, that is a big question. That is the reason why when the same thing happened with the state of Punjab, in this particular case, Supreme Court has knocked down the powers of the governor. So all these delay tactics are not permitted. You have to give assent to those bills as soon as possible. And the Supreme Court also made it very clear what bills can be reserved for the consideration of the president. Rest all have to be cleared at the state level, and that to do at the earliest. So this is considered to be a big blow for the governors. Clear? And this is the state of Punjab versus principal secretary to the governor of Punjab and another. Look at this. So the questions that are related is that, is the power to withhold a bill absolute? Is the power of governor to withhold a bill is absolute? Absolutely no, according to Supreme Court. The governors are sitting on the bills for years. The CJI, you have to remember the name of the current CJI every time. Currently it is Justice D.Y. Chandrachud. And that great personality gave a create interpretation to Article 200. And he knocked out the option of withholding consent, meaning you cannot withhold the bill for a long period. And the CJI protected the power of legislature in making the laws. The governor can reserve the bills for the consideration of the president. But what type of bills? Only those that derogate the powers of the High Court. Only such bills can be withheld and you can reserve for the consideration of the president, and not every bill. Clear? Next. Kerala governor, look at this. Kerala governor Arif Muhammad, out of 8 bills consented only one, and the rest were sent to the consideration of the president. Clear? In Tamil Nadu, 10 bills were there in the Raj Bhavan. They all were sent back to the concerned state legislature for reconsideration. After reconsideration, meaning the legislature without amending anything sent back the bills to the Raj Bhavan, and instead of giving assent, the governor sent all the bills for the consideration of the president. Clear? And this is what is objected by the Honorable Supreme Court. And when it comes to the with respect to the state subjects, when the constitution, the schedules. The 7th schedule has 3 lists: union list, concurrent list, and state list. With respect to all the items that are present in the state list, state legislature can make the laws. Clear? Even for that, there is a necessity of the consideration of the governor, and that will become the a law. Meaning is simple: with respect to the state laws, unless it is contradicting with the central laws, you cannot forward the bill to the consideration of the president. Very, 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 very important. Even with respect to concurrent list also, if a law is not existing which is made by the central government, governor has to give the assent with respect to the bill passed by the state legislature. Meaning, through this particular judgment, the CJI has given a creative interpretation to Article 200. Otherwise, governors were taking it for granted and they thought that it is their discretionary powers either to give assent or the reserve bill for the consideration of the president. But the judgment made it very, very clear that it is mandatory for the governors to give the assent to the bills unless a bill is talking about the derogating the power of the High Court. Clear? Very, very, very important one. And in the below description, you can see our app link. Please download that app, and there you also have our Telegram channel link. Click on that one and follow me through the Telegram channel. Updates will be provided to you through that. Similarly, admissions are open for APPSC TSPSC Group 1 and 2 examination. All the details are mentioned in the app, and all the students who are interested, you may please join accordingly. Thank you so much, and I'll see you in the next session.